Hello everyone, my name is John Milburn. I'm the course coordinator for Laws 19038, Planning and Environment Law, and this is our first interactive Zoom session. I just have one participant online at the moment. Thank you, David. You are most welcome to join me each week, and the idea is that we have these sessions on a Wednesday evening at 5 p.m. I will post the link through Zoom on the front page of the Moodle site. It is perhaps the main way that we communicate, but I do encourage communication by email, by using the question and answer and news forum facilities in Moodle, and that's a great way to interact with other students as well, and also through the front page of Moodle itself. In this subject, as you would have seen, there are 2 assessments only, each at 50%, no examination, so there's a bonus for you. The first assessment you would have seen is due on Thursday the 24th of April. Now that's at 5 p.m. and I'm pretty strict with times. So be warned that I may cut off the allowable submissions straight after 5 o'clock, so please be on time. The second assessment is due on Friday the 23rd of May, and that's also at 5 p.m. There are word counts and they do apply, so please try to make your assessments within that applicable word count. I think in a legal subject, it's fair to say that sometimes it's more difficult to explain what you need to explain using less words than it is using more words. Hello, Kelly, how are you? Nice to see you on board. So the subjects that we do have for, or this subject, we have 2 texts. We have firstly Philippa England's text on sustainable planning in Queensland. That's what we'll be looking at tonight. And the other, of course, is Jerry Bates' publication, Environmental Law in Australia. We're using the 8th edition, and I'll be referring to both those texts. Now, can I make this introductory comment? This subject, I think, is particularly difficult in terms of the amount of work that you're expected to cover. The reading is extensive. Bates itself is, I think, 800 pages, and we cover most of Bates as well as most of England during the course. So there's, in my view, an extraordinary amount of reading. I'm going to run the course essentially through the textbooks. The expectation is that you do read the textbooks, but you don't have to go beyond that, in my view, unless you wish to do so. Having said that, there's some excellent material on the Moodle website, study guides prepared by Dr. Lawson Smith. Those study guides, to my mind, whilst they're excellent, are more theoretically focused than the more practical books that I've set for the texts. So if you are stuck for time, the word is read the texts, and don't worry too much about Dr. Smith's notes unless you wish to go further in terms of the reading. Now, having said that, there are study guide questions, review questions, which are available each week, and my practice is to provide the answers to those study guide questions on a weekly basis. And if I remember, I'll let you know that those answers have been posted to the site. Now, just by way of background, I don't think I know anyone doing the course, and you probably therefore don't know me. I am a practicing lawyer. I practice primarily in litigation. I've been practicing since January 1984, continuously since that time, essentially as a principal. I was educated at the University of Queensland. I did honours degree in the 70s and early 80s, and I did my articles of clerkship at a firm called Cannon and Peterson, which is now known as Norton Rose Fulbright. It was known as Deakins for many years. Apart from being involved in the private practice as a principal in the law firm and course coordinator for Central Queensland, I am a member of the Queensland Civil and Administrative Tribunal, and even though it's non-assessable, I think I've put in a reference on the front page of Moodle to some of the cases that I've decided recently which have been published. I'm also I co-established the Hervey Bay Community Legal Service with a person who is now Magistrate Steve Guttridge, and I was former chair of the College Council for Fraser Coast Anglican College, and I've been re-invited to attend on that council. Apart from that, I'm a nationally accredited mediator. All right, well, that's it for me. Now, court systems. I understand that in this course, you do know something about legal principles and legal background. I understand that Joe Keogh may have taken a subject for all of you or most of you. So I can gloss over some of the more basic principles in litigation and legal practice, but please feel free to stop me during these presentations to ask any questions at any time, and of course always ask questions through Moodle or through email. But just a very basic introduction. We do have, of course, the three branches of law, in that we have Parliament making the laws, the executive administering the laws, and the judiciary interpreting and ruling upon those laws. There is no such thing necessarily, therefore, as the law, because the law, which is made up through decided cases, we call the common law, is created essentially through the judiciary, and the statutes prepared and passed through the Parliament. So we have those two different elements of law that combine. It's cyclical in a way, in that statutes are passed as a result of Parliament making decisions. Parties disagree, the matter then goes to court. The lawyers disagree, and even the judges might disagree. A decision is ultimately made. The community and Parliament react to that, and the matter goes back to Parliament, who create new laws. Then following all that, we have a change of election, and suddenly we've got new parliaments making different laws again. So it's very fluid, and the law is guided by Parliament, by the executive, and by the judiciary. What I can suggest from that is that there is not necessarily going to be a right answer, or a single right answer in some instances, and indeed many instances. So when you're answering questions which are of a legal nature, I'm more interested in your ability to identify the main issues, state what you believe the appropriate rule to be, and then argue in a position. It may be that your conclusion that the answer is red differs from my conclusion that the answer is green, but that doesn't necessarily matter. What really matters is your ability to formulate and see through an argument. So, in a sense, you are licensed in legal studies to be just a little controversial. We're not really interested necessarily in your opinion in terms of what the law should be, but we are certainly interested in your view of what the law is when you consider the interplay of statutes and case law, etc. So I hope that makes some sense. Just bear in mind that in law there are other issues that come into play. For example, in a particular case, who carries the burden of proof? In other words, who has to prove the case? And if so, to what standard? And I'll talk more about that shortly. Well, in fact, I might just talk about that now. You've probably heard of the standard of proof, or the burden of proof, or the onus of proof. In terms of the standard, in a criminal proceedings, the prosecution is required to prove its case beyond reasonable doubt. That's the level to which prosecution must rise in order to establish its case against an individual, the subject of prosecution. So that's beyond reasonable doubt. In a civil proceedings, the test is really on the balance of probabilities. What's more likely than not in that particular case? Now, both those differ from perhaps a scientific approach that many of you may be familiar with, which really talks in terms of generally a 95% satisfaction rate, if I understand the scientific test generally to be. So there are different tests that apply, and depending on your answer, if it's a criminal law matter, you need to bear in mind the much higher onus which is cast upon the Crown in prosecuting those cases than in civil cases. All right. Weeks 1 and 2, England, chapters 1 and 3. I mentioned that the texts are England, and before I get into that, I'll just mention this. The texts are England and Bates. There are some other commentaries that are well worth considering, apart from the study guides by Dr. Lawson Smith that I've mentioned already. If you're looking for publications, there is the Community Litigants Handbook, which is produced by the Environmental Defenders Office. Anita O'Hart is the author or publisher. And Environmental Law, LexisNexis Case Summaries by Brad Jessup. Both of those come at a cost, but they're both relatively modest costs and probably worth considering. In terms of online resources, you do have access to the statutes through the Parliamentary Council website, or AUSTLI, which is unauthorised but still my preference. AUSTLI is AUSTLII, and if I remember, I'll post something on. I'll put a note of the web page to AUSTLI on the Moodle site. Other than that, there is LexisNexis and Thomson Reuters. LexisNexis, you'll find, is mostly, I believe, Jerry Bates is the author for that. What I propose to do is essentially walk you through the chapters, highlight what I think are the most important issues, wherever possible refer you to a paragraph number, and then to expand on that with my own comments. Even though we're talking at this stage about England's publication, I do want to make some comments that are drawn from Bates, chapter 1, and if you could bear with me. Bates makes a comment that the development of planning environmental law in Australia has been concentrated effectively in the last 40 years. So planning and environment law is extraordinarily recent in terms of legal history. It wasn't, for example, a subject at all when I was at university in the 70s and 80s. It's an area of practice which is growing extraordinarily quickly. And part of the reason for that is, of course, that it's policy driven and it's highly politicised. So it's very topical, and there are many people in the community who, for very good reason, want to see legislation passed. So it is a growing area and a quickly moving area of law. Bates makes comment that planning and environment law in Australia is making sure that the impacts on the natural environment are identified and taken into account in decision making. I read into that administrative law is largely administrative law, and administrative law is the area of practice which deals with the executive. Now, as we mentioned briefly before, you've got the three heads of power, if I can use that term. We have the Parliament, the executive, and the judiciary. When I talk about administrative law, I'm talking about the executive function of government in terms of administering the laws that are made. Planning and environment law, however, draws its content from many other areas of practice. So even though it's only a new area of practice, it does rely on reference to corporations law, criminal law, torts law, contract law, real property law, constitutional law, administrative law, civil procedure, international law through treaties, alternate dispute resolution, and legal ethics. So there are many branches of law that come into play when we're talking about environmental law. In Bates at 113 and 115 makes the comment that the environmental movement must rank as one of the great social revolutions of history. And in most countries, the responsibility for environmental degradation was laid squarely at the feet of industry. Manufacturing concerns treated air and water as a sort of natural conveyor belt to carry away all kinds of harmful effluents that could have been disposed of in less convenient or more expensive ways. But prior to the environmental revolution, there was no pressure on them to do otherwise. One of the issues with lawyers is this, that our responsibility is primarily to the client, as one might expect. We do have an overriding duty to the court. For example, we're not allowed to mislead the court, to present something that we know to be incorrect. But in the context of environmental law, what we see is missing is any form of duty from the lawyer's perspective to the environment or to the public. And that's part of the reason why the case law has been developed in the way that it does, in that there's no overriding duty to anyone other than the client and perhaps the courts. If I could do a parallel, in child protection proceedings, it's very common now for courts to appoint a lawyer to represent the interest of the infant children who have no voice for themselves. And it may be that one day environmental law will progress to a stage where lawyers are appointed essentially to represent the public, to safeguard the interests of the environment, rather than the interests of the parties necessarily who stand before the court, in that sense. All right, now if you do want to follow me as I go, I'll now have a look at England's publication, and I'll take you to page 15. And what I've done is, by now you would have hopefully completed your reading, and I'm just bringing, I guess, my view on what's the more important aspects of it. Now, page 15, there is a note that the report of the World Commission on Environment and Development, which is the Brundtland Report from 1987, coined the phrase sustainable development in the lead up to the international conference held at Rio in 1992. Sustainable development being defined as development which meets the needs of the present without compromising the ability of future generations to meet their own needs. England at page 18 then goes on to talk about the former Integrated Planning Act as one which embraced ecological sustainability as the overarching purpose of the Act, and that's section 1.2.1. You would have also seen, and this is from page 19, that same Act involved or introduced the IDAS system, the Integrated Development Assessment System, as a key procedural change and cornerstone of the Integrated Planning Act reforms. And to quote her, she says, IDAS was and still is an integral process for dealing with and deciding development applications. We will be talking more about IDAS throughout the course, but you would have seen from your reading already that the Integrated Planning Act introduced new planning mechanisms which would allow for infrastructure development associated with development applications. Previously, councils imposed conditions as they saw fit, subject to a requirement of reasonableness or relevance. But the Act now expands on that and provides for infrastructure charge schedules. And there's some arguments in the text about why that might be regarded as better for developers and employees for budgetings, decrease in litigation, and removes the suggestion of tainted decision making as it was arguably before. Now, you would have noted in your reading the Integrated Planning Act has been overturned or overtaken by the fresh legislation, the Sustainable Planning Act of 2009. That's a Queensland piece of legislation, and I'm going to suggest to you that there are really two pieces of legislation that I would like you to be conversant with throughout this course. The first is the Sustainable Planning Act 2009, Queensland, and the other is the Environment Protection and Biodiversity Conservation Act of 1999, and that's a piece of Commonwealth legislation. I will provide you with a link to those acts on Moodle. And hopefully you are able to access acts and legislation and case law either through the official channels or the unauthorised channel of AustLII. But if you're having trouble with that, just send me an email or put on a question on Moodle, and we'll try and help you through it. Now, with the Sustainable Planning Act 2009, there was an introduction or clarification of the hierarchy of planning instruments. So at the top of the tree we have the regional planning and regulatory instruments, below that the regional plans, below that the state planning policies, and then below that the local planning schemes. England at page 25 makes the following observation. In addition to prioritising regional planning instruments, the Sustainable Planning Act extends the scope of state planning policies, allows for the standard planning scheme provisions, anticipates standardised state-drafted schedules for infrastructure charging, and strengthens ministerial powers. These reforms, therefore, follow the principal recommendations of the Queensland Development and Housing Local Government and Planning Report 2007. It might be an appropriate time just to raise an issue off England, and that is the topic of Commonwealth versus state jurisdiction. Now, I'm not sure how much law you've done and whether you've covered this or not, but I think it's something I should introduce right at the start. I've mentioned two acts, one state and one Commonwealth. The authority of the Commonwealth to make laws is principally contained in the Constitution, more specifically Section 51 of the Constitution. Now those powers which are conferred upon the Commonwealth government to make laws are limited. They don't have the power to do absolutely anything they wish. They are limited in terms of the areas of responsibility that they have. The states are entitled to make laws in relation to subject areas referred to in Section 51. However, if they do that, Section 109 of the Constitution is relevant, because in that section it states, when a law of the state is inconsistent with the law of the Commonwealth, the latter shall prevail, and the former, to the extent of the inconsistency, be invalid. The Commonwealth doesn't have power, express power, to make laws in relation to the environment. It's not one of the listed areas of responsibility conferred upon the Commonwealth government. In other words, there's nothing in Section 51 that says the word environment. But in environmental law, as is the case in many other areas of Commonwealth jurisdiction, they seek to make laws by relying upon other, perhaps allied powers. For example, the Constitution does confer upon the Commonwealth power to make decisions in relation to trade and commerce, corporations, and external affairs. It's for that reason that the Commonwealth is able to make or pass laws in relation to environmental matters. The Commonwealth power to legislate may rely upon its external affairs power, and they use the external affairs power as a means of implementing international treaties, and therefore legislation follows as a result of that exercise of the external affairs power, even though the legislation is essentially environmental in nature. Some examples of that: the World Heritage Convention of 95 and the Convention on Biological Diversity 1992. A person is, however, bound potentially by both state and federal law, and in some circumstances is required to consider and abide by both pieces of legislation All right. Now, that is all I propose to say in relation to what was nominated as the work for week 1. Before I do, does anyone have any questions?
No, I don't at the moment, John.
Thanks, David. All right. All right. Well, if you're happy to move on, what I'd like to do is now go back to England, and in particular to Chapter 3. The former Act included a number of state planning instruments. However, as England describes at page 51, there were some inherent flaws in the IPA system. For instance, one of the state planning instruments, being the State Interest Review, for drafting planning schemes caused lengthy delays. The power to designate land for future community infrastructure was not frequently used because it triggered statutory rights to compensation. State planning policies remained few in number, and the influence was indirect. Regional planning fared even more poorly. We contrast that with the Sustainable Planning Act, which provides for those 4 issues that I raised before. Firstly, state planning regulatory provisions, which is England pages 53 to 55, regional plans 56 to 73, state planning policies 73 to 81, and standard planning scheme provisions 81 to 83. I'm not going to repeat everything that's written down. I'll leave you to enjoy that process, but I would like to bring some issues to your attention. Firstly, the first of those 4 points, state planning regulatory provisions, and if you wish to follow me, this is England, pages 53 to 55. The comment is made quite rightly that state planning regulatory provisions are the preeminent type of planning instruments created by the Sustainable Planning Act. A state planning regulatory provision, says England, is a legally binding instrument which prevails over every other type of planning instrument made under the Sustainable Planning Act or another act. A state planning regulatory provision may be made by the Minister for a number of reasons, and I'll get you to see England at page 53 for an outline of those reasons. That's number 1. Number 2, regional plans, which is England pages 56 to 73. Section 23 of the Act notes that a regional plan is an integrated planning policy that seeks to advance ecological sustainability in a designated region. It is a legally binding instrument. That's section 24. With the exception of state planning regulatory provisions, a regional plan takes priority over all other planning instruments under the Sustainable Planning Act, and that's section 26. At page 57, England identifies a case study involving the South East Queensland Regional Plan. And at page 63, England refers to sections 283, 313 and 314, where she says these sections require referral agencies and assessment managers to assess applications for code or impact accessible development against any applicable statutory regional plan. So from that we can see the importance of the state regional plans in the context of the overall planning hierarchy, and how regional plans need to be considered by assessment managers in dealing with code or impact accessible developments. There is some very interesting case law on that, which is referred to throughout the course and the texts. There is an issue in relation to compensation, and this is still under the heading of regional plans. England at page 68 says there remains an ongoing dispute about the question of compensation. She makes reference to the case of Chang against Laidley Shire Council. You'll see the reference in the book is 2006 146 LGERA 283, where the Queensland courts accepted the argument that compensation should not be paid because the pre-existing scheme to compensation did not apply to an application that could no longer be properly made. Right, what does all that mean? Well, in this case, it occurred as a result of the introduction of the draft regulatory provisions under the South Coast Queensland Regional Plan, which differed to earlier regional plans. Sorry, SEQ plan. Now, the High Court in 2007, in that same case of Chang and Laidley, agreed. And the decision in Chang confirmed that the regional planning provisions of the Integrated Planning Act from 2004 absolve the state from responsibility to pay compensation for injurious affection caused by regional planning instruments. That comment is made at page 69. Accordingly, planning agency can now regard the public benefit as the dominant consideration in the knowledge that it need not be subject to large compensation claims in relation to changes to planning schemes. Can I contrast that statement that I've just made with a statement that I made earlier in terms of the way in which the predecessor act, the Integrated Planning Act, operated? You'll recall that state interest reviews were not used often because they did frequently trigger statutory rights to compensation, and therefore those policies and those reviews did not occur regularly or at all. Now, so there's much more freedom for planning agencies now under the Sustainable Planning Act than there was in the past because of the removal of that fear of a payout of large compensation claims for changes to planning schemes. So just to recap, we've talked firstly about the head of the hierarchy, if I can use that term, the state planning regulatory provisions. Below that, we've talked about the regional plans. I'd now like to move on to the third level, which is state planning policies. And you can read about this in England at 73 to 81. Sections 40 and 41 of the Sustainable Planning Act allow for advancement in ecological sustainability by stating that state policy matters can be made in relation to matters of state interest. Now, what does state interest mean? It means something which, in the opinion of the minister, is an interest affecting an economic or environmental interest of the state, including sustainable development, or an interest that the minister considers affects the goal of ensuring that there is efficient, effective, and accountable planning and development assessment system. In my view, that confers upon the minister, acting in his or her executive function, very wide-ranging powers. And I'm not suggesting in any way that they can be abused or have been abused, but they are very wide because we're really talking about the opinion of a single minister. Page 74 through to 81 is where you'll find commentary by England about a case study involving koala conservation in southeast Queensland, which talks about the way in which state planning policies have been considered by the courts in terms of dealing with legal issues and legal disputes. So what can we make about state planning policies? How do they fit into the scheme? Well, perhaps what I could say is this, that state planning policies and having them clearly articulated and documented does help to provide certainty, and clearly that's of benefit to all stakeholders. I talked about the previous system, even before the Integrated Planning Act, where councils could impose all sorts of conditions, provided they could establish that they were reasonable in the circumstances and relevant. But now we have a much clearer articulation of planning policy and planning laws generally throughout the hierarchy, which helps the system and helps everyone involved in that system. I guess in a way what we're really doing is reflecting upon the fact that environmental law and planning law is extraordinarily recent, so things are changing quickly, as we would have seen already. All right, so to recap, I've talked about state planning regulatory provisions, number 1, regional plans, number 2, state planning policies, number 3. The fourth is state planning scheme provisions. Section 51 of the Act provides that the instrument consisting of the state planning scheme provisions is a legally binding statutory instrument. So once again, it's legally binding. At page 82, England states that the standard planning scheme provisions will form the basis of all new planning schemes under the Act. Each local government will need to ensure that local planning instruments made under the Act are consistent with the standard planning scheme provisions, that's section 55. The standard planning scheme provisions are the key reform made to planning by the Act. That comment is made at 82, and it is intended that their introduction will make the preparation of local planning schemes, quote, easier, quicker, more efficient and cost-effective for councils. So, what can we conclude from that? The first is that state planning instruments are collectively designed to ensure that proactively governments are dealing with planning and development issues. They have to be proactive because there is considerable economic, ecological and political pressure to bear upon governments to ensure that legislation keeps up with policy, and policy in this area moves quickly. So having the instruments in place allows for governments to plan in a much better way than perhaps might have been the case before the introduction of the Sustainable Planning Act. The comment is made, and I support this, that it's hard to believe that cohesive planning could have existed in any meaningful way prior to the introduction of the Acts, that is the Integrated Planning Act and or the Sustainable Planning Act. Perhaps it did not, which led to the surge of activity in relation to environmental law in Australia. So because there was a relative dearth of cohesive planning, there were instances where there was a cause to be taken up, either political cause or perhaps a legal cause, and that has led to the introduction of these more cohesive plans that are referred to. Now, in study guide number 2, Dr. Lawson-Smith outlines in much greater detail the history of the planning process and the reasons for the introduction of the Act in 1997. So if you want to do a bit more reading in that regard, I'd commend the study module for you. The performance-based Integrated Planning Act is premised on ecological sustainable development. Thus, section 1.2.1 of the Act from 1997 provides that the purpose of the Act was to achieve ecological sustainability by coordinating and integrating planning at the local, regional and state levels, managing the process by which development occurs, and managing the effects of developments in the environment, including managing the use of premises. Those concepts have flowed through into the Sustainable Planning Act of 2009. All right. I know that's a very brief overview of what is in the text, many words, and I appreciate that it's a little dry, the subject, but it becomes much more interesting when you start to read the cases and reflect upon how the courts dealt with these issues, it also becomes much more interesting when one considers the political aspect and how the governments introduce and create these pieces of legislation as a result of a desire to implement policy previously made. That brings tonight's session to an end, save for questions, which I'll ask for shortly. But I would ask that you please direct your questions through Moodle as much as possible. I'd like to see some interaction between students, so please keep that in mind, and obviously start working on those assignments. Now, before I sign off, do you have any questions?
No, thank you. No, not yet.
Okay, thank you. Any other questions? All right. Well, thank you very much for your participation. We'll see you next week, and I'll stop recording now. Thank you.